Breaking news are just coming in. President Jacob Zuma has filed a conditional counter-application in the Gauteng High Court against Democratic Alliance's application, saying that the president must comply with the remedial action suggested by the Public Protector's State of Capture report. The president has filed an answering affidavit in which he is resisting the relief sought by the DA. In a statement, the presidency states that the legal advice obtained by the president is that he is in law not entitled to just comply with the report of the public protector if there are reasons to doubt its correctness. To do so will amount to a mechanical response, says the presidency. The president was further advised that the implementation of the remedial action in the current form would render academic the review application in its entirety. The DA has contended that the situation, or the institution rather, of the review proceedings by the president does not stay or suspend the implementation of the remedial action, but that in addition to the review proceedings, the president should have obtained a court order staying the enforcement of the remedial action.
NN7 Special Projects Editor Cecilia Russell joins us on the phone line. A very good morning to you, Cecilia. What is your opinion on the legal advice that has been given to the president in regards to not complying with the remedial action in the Public Protector's report?
Well, it's interesting. It was not, that Zuma should, in the interim, even if he was taking the Public Protector's report on review, nevertheless started the implementation of the report. The basis for his for the president's objection is around the fact that in the remedial action, it is suggested that in fact the judge should appoints the Commission of Inquiry, the judge for the Commission of Inquiry, not Zuma. And he is saying in his and Zuma is saying this is bad in law because it is the president's prerogative to appoint a judicial Commission of Inquiry. I don't know there's been any issue around him actually wanting to perhaps do the Commission of Inquiry. So he's come back saying that, it's not, you can't just mechanically do something if you have a problem with part of it. And if there's adverse against you, then you need to be able to the legal advice basically advises him that he shouldn't agree to comply with part of the Public Protector's report, even if he disagrees with the other part.
Now, Cecilia, there's a section here that says the DA has contended that the institution of this review proceedings by the president does not stay or suspend the implementation of the remedial action. What exactly does that mean?
I think what they're trying to say is that the president, I remember this was the Nkandla case. The court found that the only thing that anybody could do if they objected to a report of the Public Protector is to take the report on review. So I think that what is indicated here is that that he may be able to take it on. They're suggesting that he should still nevertheless continue with the remedial action and simultaneously to the review proceedings, that they're not, the one doesn't suspend the other. So the DA seems to be arguing that they should continue with the remedial action, and the review proceedings can be a parallel process. Zuma's lawyers are saying no, these cannot be parallel processes. This is one process. We need to deal with the issues in contention, and then we can deal with the rest of the report.
Well, they are saying that the president should have obtained a court order staying the enforcement of the remedial action. What do you think about this statement by the DA?
That they should have got a court order?
Yes, that the president should have obtained a court order staying the enforcement of the remedial action as well as the review of the Public Protector's report.
Well, I'm not a legal analyst, so I'm not really able to say whether that is good in law or bad in law. I think what the DA has been trying to do is through the courts push for this commission of inquiry. The interesting thing about it is that Zuma has never said that he is anti a commission of inquiry. What he is anti is the fact that his rights have been violated, his constitutional rights have been violated about the setting up of the commission of inquiry. It is his prerogative constitutionally to set up a judicial commission of inquiry. So what they're trying to do, I think, is force his hand so that you'd have both happening simultaneously, and presumably the one process wouldn't influence the other, but in terms of the public eye, it may do so. So it's quite a difficult situation. But the DA seems to think that these are two processes, and they should be dealt with differently, separately.
Well, thank you so much for helping us to dissect the statement. That was ANN7 Special Projects Editor Cecilia Russell joining us there on the phone line.